It is March 11th, 2026, and this is the Court Gallery. Ladies and gentlemen, today we are witnessing life, prison, and last chances from the Court Gallery. One defendant's future hinges on a mother's incredible courtroom speech in front of Judge Simpson, while another learns she is facing life behind bars from Judge Hesselink. We'll see Judge Mogan's creative sentence for a man who almost got away with felony strangulation, and Judge DeSanto's raw disgust for a violent domestic assault. Finally, we'll hear about a guy who tried to outrun a Motorola and failed. And maybe I'll figure out how to use words somewhere along the line. In any case, ladies and gentlemen, as usual, welcome to the Court Gallery. It all starts right now.
Court does call the case versus Tegan Donnell.
Mr. Judge, portion of people to speak and post defender on behalf of the Tegan Donnell. Please state your name for the record.
Tegan Donnell.
Donnell. Thank you, Judge. We have received the recommendation by probation. Mr. Donnell understands all the conditions and she's asking that you follow the recommendation thereon.
Tracy Clare on behalf of probation, Your Honor, the victim, Kathy Donnell, Tegan's mother, is present. She did provide the court with a written statement. She would like to verbally address it.
I have a seat over here.
Hello, Your Honor.
Hold on. State your name.
My name's Kathy Donnell. I'm the mother of Tegan Donnell. I did provide this 3-page summary of kind of historically. I hope you had an opportunity to review that. But then when Ms. Pilara said I could talk today, I thought, what could I say to add to that? And I just want to thank you for the opportunity to address the court today. I'm the person who filed those initial complaints against my daughter. I've submitted this lengthy letter with my recommendations and suggestions. And I've spoken to Ms. Pilara, the probation officer, and Ms. Roddy, the victim advocate, and they assured me that all the letters got sent to the appropriate people. I just thought, what could I add today? I just wanted to express that I know I'm not the only parent who deals with these challenges. And like many parents, old as I am, who are still working full time and single parent of adult children, single parent for 25 years, I realize that there are a lot of single parents who also love and try to raise their children to experience a full range of life with hopeful outcomes. The comorbidity of serious mental illness and substance abuse represent huge challenges in our lives every day. And if it's not one of your children, there is someone in our family or someone we know close to us that deals with those same issues. I don't have statistics with me, but imagine most of us in this courtroom can say we are related by just 1 degree of separation with either a parent, a brother, sister, aunt, uncle, cousin, with diagnosis of alcohol and substance abuse or mental health diagnoses or dual diagnosis. I have 2 adult daughters, 2 of my 4 children with serious mental health and substance use disorders. And I've been present for both of these daughters for serious charges here in the court. Admittedly, I have watched from YouTube and been present and, for many of your courtrooms. And I appreciate how you handle these with grace and respect still. and humor, as someone else mentioned this morning. I proactively support both my daughter's engagement in mental health since they were adolescents, but somehow it's not sufficient. I can clearly state that neither of my daughters the same person I know when they're clean and sober. Clean and sober, their innate values emerge again. Tegan is two different people from the night this altercation occurred than when she is sober. And I've observed this person on numerous occasions, but for the past few years, I have told her she can't live with me any longer, and she ended up homeless. I see, however, it's hard to stay sober with, the mental health issues, and when you're homeless, and then it's kind of a cyclical process. And for Tegan, some of these substances often facilitate some psychotic and paranoid thinking. And it's really hard. I'm a psychologist, but I know it's really hard to get the right medications. It's a very trial and error effect. But here's my bottom line for Tegan. She's an exceptionally bright young, has been vivacious in the past, probably still quite depressed, going through medication, again, adjustments. But she was precocious, the youngest of all of her siblings. School was easy for her, even high school. She says it took her 7 years or 8 years to graduate from EMU, but she does have an undergrad degree, which says a lot for dealing with all of this. And there's a combination of factors that impacted her development: drugs, depression, anxiety, peer ridicule, parental divorce, numerous moves, financial struggles, living with a father and sister with severe mental health and substance use disorders. But there are those who are resilient with it all, and they seem to survive and flourish, but many don't. I know that my daughter genuinely cares about people, all people, which sometimes increases her vulnerability, puts her at risk. But in that respect, I'm grateful to the court, who provides deterrence and supports with helping her get and stay on track. I can see her as a contributor to our community, maybe hopeful that she can provide legal advocacy for others someday. She's definitely had exposure to attorneys and courtrooms, and maybe she'll engage in social work and clinical or research or teaching, special education or medicine. I remind her that she needs time to allow her brain to develop new neural pathways. But I truly believe this experience fostered by the court system can make a difference in the long term and how she can potentially contribute to others. If there are any opportunities that you all can facilitate via courts or CMH, that would be an amazing opportunity for her to see some of her strengths emerge again. I apologize for being wordy.
No.
But
It's a mother's prayer.
right, true. And that's what Ms. Pilara said to me. So this is an opportunity to present to the court. Again, in addition to the more specifics I already submitted, I realize that I'm grateful, and that along with 3 of my 4 children, my son lives 3 hours away now, but 3 of the 4 still live in a community where the legal structure accepts and works with individuals to mediate their mental health substance challenges, and of course, to protect our citizens. I've had an opportunity, I see this really as an opportunity to thank so many members of this community for their service. I don't know how many times you all are told thank you for what you provide to our community. I've usually been here on Thursdays, which is a much more robust gathering. But so I just want to, that's the thing that I could add today, was that thank you for your service in providing a safe and judicious courtroom, Judge Simpson, for occasionally being able to note humor that arises in a very tough room. And I wanted to, usually I know the prosecutors are here, but I wanted to say thank you to them for their service, and victim advocates, and to Ms. Polora for facilitating a good plan for my daughter. And she's worked with one of my other daughters as well. And to thank the court-appointed attorneys for all your work, and there have been many connected over the years, and to Community Mental Health, CMH, and their crisis team, and for the quick and supportive response from the Pittsfield Township Police and ambulance services who have been to my home on too many occasions to count. And grateful to the support for Ann Arbor Police, who supported and assisted Tegan's older sister. And so it's a tough battle. I know there are many people who deal with this, and but it does take a village. And so while I feel it alone at times, as many parents with these challenges, I'm grateful to each of you for helping my family, and I'm grateful to live among all of you in our village. So
Which I may ask, what do you do?
I'm a clinical psychologist at the VA.
I would not have known.
But it's hard, because you would think you could make life different for your kids, you know? I mean, with all the knowledge,
Right.
it's still a tough road out there. And I believe that most everybody deals with this in some way, just in a very, not, as I say, again, just one moment, one level away from all of us. So thank you again.
Thank you.
And thank you to everybody for your support.
Thank you very
Thank
much.
you.
Appreciate you. Thanks.
Ms. Fuller.
Yes, Your Honor. There is one thing that I did not incorporate in my report to the court.
Yes.
Ms. Donnell has completed inpatient treatment. She is attending outpatient at John Farm. She is also so she has settled in there. She is on a GPS tether that was ordered by this court. Given that she is in a good place now, probation is recommending that GPS tether come off. I believe that Ms. Donnell is going to, comply with the terms of her probation, and she is engaged. I believe that someone from the program slipped through today. So she's out.
What's that? Okay. Well, I saw the three of them sitting back, so I knew that in some way they were all together. So. Okay.
Thank you, Judge. We have reviewed everything, and we've heard Ms. Pilar's additions to the recommendation. We'd ask that you follow all those conditions, and I believe Ms. Donnell can be very successful, and she's on the right path, Your Honor. So
Right.
she's on the right path. So I ask you to give her the opportunity to continue that, Judge.
You get anything you want to tell me?
Your Honor, thank you very much for letting my mother speak. That was very meaningful. I'm trying to move forward on the same path I'm on currently. It's been difficult. It's been a long road. I appreciate your help.
And I noticed your reaction as your mom was speaking, because a lot of that probably resonated with you, right?
Yeah, it resonated with me, some of it. I was like, Mom, why are you saying this in public? A lot of it was really important to me to hear.
Yeah. So of those things your mom was saying that, I mean, I think with every kid, the parents start talking and they get kind of embarrassed by something. Why do you think your mom did that?
I think my mom has gone through a lot with me and one of my other siblings. And I think it felt like her chance to finally speak. And it was a moment where she finally had an opportunity to say something. And I know my mom wishes she could change the world and wishes she could do a lot more for people and for her children. And she did everything she could for us and was the best mom she could be and is the best mom I've ever had. And is a great mom. So it's like she had it was like a moment where she had the opportunity to speak, and I'm really, really grateful she had that moment. So I don't know what else to say.
No, it's okay. You're good. Most amazing thing about it, quite frankly, is I was listening to your mom, and I'm kind of caught up in her words. But that's why when she apologized about being wordy, I bothered me one bit. I think, you know what, Tegan, sometimes we don't count our blessings in life. We take a lot for granted, right? And sort of a strange thing, your mom was talking about parents. It's a strange thing about parents because I'm sure you and your other sibling have just put her through some paces, right? And the interesting thing is if she didn't love you, she could have just given up, right? And that's a blessing, right?
Yeah.
She, through everything, maybe that's what a real parent's about, through everything, she never stopped loving you. She might not have always had the answer, but the one thing you probably knew, stop loving.
Right.
Part of what she was saying, certainly she was in some ways probably talking to herself, probably saying some things that she's probably said in her head over time and time again.
Mm-hmm.
Part of it, certainly she was talking to those of us in the system, but she's talking to you too, right? But the greatest thing about what she was saying, which was really sort of just interesting to me, is she really was talking about the people out there that face the same challenges. And bottom line to everything that she said, and again, I don't think she was being wordy at all, is she was really saying, don't give up hope, right? Just don't give up on your kid. You just got to kind of try to get through it, or if it's not your kid, but it's somebody else, you got to try to through that. And I think for those of us that are in the system, she was also by thanking us, telling us not to give up.
Absolutely.
Got a great mom, Tegan.
I do. I know I do.
I know you know, right? But you really do. And she'll stay with you. All right. And you just gotta walk sometimes that slow journey, but you gotta walk it. Okay. Sentence on count assault and battery. Sentence of the court. I'm gonna place you on 18 months prosecutor deferred sentence. If $555 fines and court costs, $540 probation oversight fees. I'll ask you about payment. There should be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You are to complete the non-farm outpatient program, including all recommended aftercare with status reports to probation. You're to continue your individual therapy with proof to probation. You're to attend a minimum of 3 AA meetings per week with monthly verification to probation. I'll allow consensual contact with Kathy Donnell. There's to be no assaultive, threatening, or intimidating behavior on your part. You are not to possess weapons, firearms, ammunition, or anything fashioned to be a weapon. You are to begin and maintain employment. I will set a review hearing on this charge for September 8th, 2027 at 9 a.m. I'll order 93 days in jail. Credit 1, the balance is suspended. On count 5, the larceny less than $200, 18 months probation, $555 fines. Court costs you to comply with the sentence I've just set forth in count 4. And I'll order 93 days jail. Credit 1 day served. The balance is suspended. I will order removal of the GPS. How are you going to get this paid?
I just got a job. I have maybe $10 right now. Around there. But I have a job and I'm starting to work.
You have a job?
I just got a job. And I'm starting to work, so it will be paid off over time.
So how long do you think this is going to take you?
A while.
A while? Like, what's a while?
I don't know.
You have no idea.
I don't.
I know, because, well, you don't have any idea, because
I would have to do
when mom's allowed you, you lived under mom's roof, right?
I mean, I've been homeless for many years.
Okay.
And now I have rent because I'm living in transitional, which is amazing. I'm lucky, but I don't know. It'll take a while. I will pay it off as possible.
How long have you been sober?
2 months today.
Today?
Yeah.
Congratulations.
Thank you.
Mikey, that's fantastic. Were you not going to tell me that? That it was 2 months today?
I wasn't gonna.
That's something to celebrate. That's beautiful.
Thank you.
All right. Tell you what I'm going to do for you. Right? I don't know what this totals up to be. Figure out what your income is.
Like-
Payment plan
Yeah.
as directed by probation.
And then the tether is another.
Pardon?
Tether costs extra too, right?
Yeah, but he said no more tether.
Oh,
She was wondering about paying for the tether in addition to paying the fines.
I'm going to remove that. You can deal with community corrections about payment on the tether.
okay.
I'm not going to get involved in any of that.
Well,
$650.
that'll take me like
Let me ask you,
months to a year.
you're committed to staying sober, right?
Yes, sir.
Now, your mom said that when you stay sober and you do that, then you're the daughter she knows,
Correct.
right?
Correct.
The good daughter.
Yes.
Yeah, okay. So here's what I'm gonna do. Because I want your mom to have and be able to experience that good daughter, but it's gonna take work on your part, right? Okay, so Miss Polero, her total amount that she owes is $1,650. Starting today, we've got 18 months probation. So what I'm gonna do is each month you're sober, we'll just take $100 off.
Wow. Thank you very much.
All right. I'd rather have your sobriety than the money. Yeah, that's
Very, very much.
right. We'll take $100 off until we get down to the state minimum. So won't do that, but I think that'd get us through your entire probationary term. All right. And young lady, part of doing that for you, but you got to do this variety part for yourself, right? But I'm also doing that for your mom. It's the least of what she deserves. Okay. All right.
All right. Thank you very much, Your Honor.
Thank you. Let's take time.
Thank you. Thank you, Judge.
Thank you.
All right.
Right on time. Court will call the matter of the state of Michigan versus Joanne Baumgartner, file 26-44422-FY, scheduled for an arraignment. And we are also here on the matter of the state of Michigan versus Joanne Baumgartner, file 25-44031-SM, scheduled for a probation violation review. Ms. Baumgartner, I'm Judge Hesselink. I'm coming to you from the 87A District Court. You're here for an arraignment on two cases. First is the new felony matter. There are two charges against you in that matter, and it reads as follows. It says that on or about March 10th of 2026 in the city of Gaylord in Otsego County, that in count one, you did commit the offense of mail and mail depository protection act theft, in that you did take, hold, conceal, or destroy mail addressed to another person, that is Richard Allen Maddox, with the intent to deprive the person to whom the mail was addressed of the mail. That would normally be a misdemeanor with a 1 year and or a $500 fine. However, the prosecutor has charged you with having two separate subsequent offense notices. The first is under that mail statute, which says that you were previously convicted of violating the mail theft statute on or about December the 20th of 2025 in the 87A District Court for Otsego County. And therefore, under that enhancement, it would be a felony offense up to 5 years and or $1,000 fine. However, the prosecutor has also filed a habitual offender fourth offense notice, which reads as follows. It says that you did make or were previously convicted of 3 or more felonies or attempt to commit felonies in that on or about January the 24th of 1994, you were previously convicted of the offense of assault with a dangerous weapon in the 46th Circuit Court for Otsego County in the state of Michigan, and that on or about December 20th of 2019, you were convicted of the offense of obstruction of justice in the 46th Circuit Court for Crawford County in the state of Michigan, and on or about December 20th of 2019, you were convicted of the offense of identity theft in the 46th Circuit Court for Crawford County, and therefore you are subject to a penalty of up to life imprisonment. Do you understand the name of count one? Ms. Baumgartner, do you understand the name of count one to be mail theft?
I'm having a problem understanding this stuff.
The name of the count one that's made against you, that name is mail theft. Do you understand that?
Okay.
The maximum possible penalty, because you have a number of prior convictions, is up to life imprisonment. Do you understand that?
Yes.
All right. Count two is a count similar to count one in that the name of it is mail theft. And it reads as follows. It says that on or about March the 10th of 2026 in the city of Gaylord, Otsego County, that you did take, hold, conceal, or destroy mail addressed to another person. And then there's a long list of persons. So I'm going to read all of their names. Randall Beauregard, Christopher Rickman, Myron Harris, Tina Patel, Ryan Bethel, Vaden Sands, Ajani Edmondson, Caesar Bernal, Kaylee Ferris, Valentina Sierra, Amanda DeSnyder, Jess Vega, Brian Price, Victoria Dort, Ned Gill, John Hasbany, Therese Kablinski, Randall Banks, Richard Meserve, Ronald Forward, Carl Laffler, Destiny Duncombe, Andonis Forbes, Chester Makoviak, James Masher, Michael Abersane, and Scott Sutton. So the charge is that you did take, hold, conceal, or destroy mail addressed to all of that list of persons with the intent to deprive the persons to whom the mail was addressed of that mail. That would normally be a misdemeanor offense, as I explained in count one, but there are two subsequent offense notices, which are exactly the same as in count one, so that the effect is that you were previously convicted of 3 prior felony convictions that I previously read to you, so that the maximum penalty for count two is now life imprisonment. Do you understand that count two has a name called mail theft?
Yeah, I guess.
And do you understand that the maximum possible penalty because of the second or subsequent offense and habitual offender notices is that you are subject to a penalty of up to life imprisonment?
No.
What don't you understand about that? You've been convicted of prior offenses of mail theft and also prior felony offenses. And because of that, the statute allows you to be sentenced up to life imprisonment. Do you understand that?
I'm having a problem concepting this.
The concept is that you could go to prison for the rest of your life.
No, I don't want that.
I didn't ask if you wanted it. I just asked if you understand that you could be going to prison for the rest of your life.
Yes.
All right, thank you. Right now, you have certain rights as to both of those charges, and that includes the right to plead guilty, not guilty, or to stand mute, the right to be represented by an attorney, and the right to have a trial in front of a judge or a jury. We'll talk about your right to an attorney in just a minute. Your trial rights include the right to see, hear, and question all the witnesses against you, the right to present your own witnesses and evidence and get a subpoena from the court to require your witnesses to appear and testify. At a trial, you could also testify or you could remain silent. And if you chose to remain silent, that silence could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt. And that burden of proof would remain with the prosecutor's office at all times. Finally, at a trial, you'd have the right to automatically appeal any error. However, if you enter a plea in the future, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand those rights?
Yes.
Do you have any questions about any of those rights?
No.
Mr. Brown, have you had a chance to speak to Ms. Baumgartner about her right to an attorney?
I have, Your Honor. She would qualify. I did represent her on the previous matter, and while I have not received the appointment yet, I was notified I am going to be appointed.
Thank you. All right, Ms. Baumgartner, until you've had a chance to speak with your court-appointed attorney, I'm going to enter a not guilty plea on your behalf in order to protect your rights. I'm also going to set a couple of quick court dates to protect your rights. The first is called a probable cause conference. That's a chance for your lawyer and the prosecutor to meet, discuss the case, and try to resolve it quickly. That'll happen within the next 7 days. I'm also going to set a preliminary examination within the next 21 days. That's a short hearing in district court in front of me as the judge, where the prosecutor has to prove a small amount of evidence called probable cause that you have committed the crimes that you've been charged with. That is not a determination of guilt or innocence. It's simply a check to see if there is sufficient evidence to proceed with the case. Do you have any questions about those two proceedings that I just talked about?
No, but I do have a question.
What is your question?
Can I get out on bond?
That's what we're going to talk about next.
Okay, thank you.
So what I'm going to do with that question is I'm going to give both of the attorneys a chance to tell me what they think I should do. And then I'm going to give you a chance to tell me what you think I should do about bond. Go ahead, Ms. Brucker.
Your Honor, what brought this to the attention of law enforcement was a neighbor of defendants had noticed some of his mail had gone missing. He set up a video and he captured her on video taking mail from his mailbox because she had previously done that as well. In the course of the investigation, law enforcement officers located around 27 or 28 pieces of mail in her possession that belonged to other people as well. As the court knows, she is currently on probation for the same offense from August of 2025. What elevates this crime a little bit is her criminal history, which includes things like identity theft from 2019, resisting and obstructing, obstruction of justice, 2020 false report of a felony, 2019 attempted larceny, and of course, that mail theft from last summer as well. I would request, as far as terms of bond, that she not have any contact with Richard Maddox, that she not possess any firearms, that she report to community corrections, that she not leave the state without permission and attend each and every court hearing and not commit any additional crimes. Because she is on bond, even though it's a misdemeanor bond, we would be requesting a little higher than we usually would. We'd be requesting $10,000 cash or surety. I'm sorry, I said bond, I meant probation.
Yep, thank you. One question, Ms. Brucker, there appears to be attached to the pretrial release potential order that I would sign on bond, a list of the same names that I read to her as being victims of count 2. Do you want to have that entire list entered as no contact?
Yes, Your Honor.
All right, thank you. Mr. Brown, your thoughts on bond?
Thank you, Your Honor. The court is familiar with Ms. Baumgartner. I've represented her in the past. She is a local resident here. She does have ties to this community. She is disabled, currently receiving disability. To my knowledge, she generally shows up for court. I don't know if she's ever failed to appear. She has some civil cases on in circuit court, to which I believe she has always appeared for those. She is going through some mental health issues. She went through some medications that she apparently has at the moment. I don't know how many she has, but it was a lot of medication she's on. And to be honest, I believe her mental health probably plays quite a large part in these allegations. With the court reading those myriad names, I don't know if the mail was allegedly opened or anything, but it is just one of those things. The benefit is really hard to see here. So I believe that there are a lot of underlying mental health issues that she is in need of help with. She is currently seeing a psychiatrist. I'm not sure when her next appointment is, but I would ask the court to take that into consideration when setting a bond, as well as, I guess I don't know, those are a lot of names listed. I don't know if she lives near these people, if this is an apartment building, a building complex where all these people are very closely situated. That may be an issue as well.
Ms. Baumgartner, you have the right to address me as to issues concerning bond. I would simply caution you not to make any statements about the facts of the underlying case, because we are recording this and it could be used against you later. But I'd be happy to hear anything that you have to say about bond type issues. Is there anything that you want to tell me now?
No, not other than the fact of, what would I have to come up with to bond out?
That's what I'm going to think about and decide in just a minute. So do you have any comments that you want to tell me about, or anything else that you want to say?
No, I'm just trying to figure out, I know probably the dollar amount that I could pay, but I just need to know how much the bond would be, and then how much I would have to pay to get to bond out.
How much money do you think that you could pay to get out of jail?
I think I could probably pay right now, probably about $400. I have other bills that I gotta pay, and I got my auto insurance to pay, and then I have other obligations that I have to pay as well. So that would be what I could do. So if you please consider that, I would greatly appreciate it.
All right, thank you very much for that information. All right, the two issues that the court needs to address in dealing with bond, or the two major issues the court needs to address in dealing with bond, are the ability of the defendant to appear on time, and then the dangerousness or threat to the community that the defendant poses, safety of the community. As to whether or not Ms. Baumgartner will appear, she has appeared in the past in multiple criminal cases, multiple civil cases. However, there has been also issues with her appearance when she does appear, as she has been, by court order, excluded from the court premises and property due to inappropriate behavior to court staff. And that's an ongoing order that is the court takes judicial notice of. In addition, this is alleged to be a second offense, very similar to an offense she's on probation for, was sentenced for in December of 2025 for the misdemeanor offense of mail theft, and is now barely 3 months into her probationary period on that offense. In addition, the likelihood of her appearance goes down with the severity of the offense. She's now charged with not only a felony offense, but 2 felony offenses, both of which are, because of this habitual offender statute, now potential life felony offenses. The court takes judicial notice that life is not likely to occur, but there is likelihood to be quite a bit of jail time, if not some prison time, as a result of this conviction, if she were to be convicted. For all those reasons, the court is going to set bond at $10,000, cash surety or 10%. That means, Ms. Baumgartner, that you will have to post $1,000 in order to be released from the jail. If you are released from the jail by posting that amount, there are conditions that you would have to follow. Those include personally appearing for any scheduled court date, abiding by any judgment of the court, not leaving the state of Michigan without the permission of the court, not committing any crime while on release, immediately notifying the court in writing of any change of address or telephone number. There is to be no use of alcohol or illegal controlled substances while on bond. You must participate in a substance abuse testing or monitoring program. That would be through Community Corrections, which is the agency that the court uses to monitor people that are on bond. You must also participate in a specified treatment program for any mental condition. That would include a community mental health assessment and treatment, and follow all recommendations. You may not purchase or possess a firearm or other dangerous weapon. May not have any contact with, direct or indirect, with the following persons, and that's the list of people that I read to you contained in count 1 and count 2 of the complaint. And there's also an attached list, which I will require to be given to Ms. Baumgartner so that she's aware of who those people are. She may not have any direct or indirect contact. That means no personal contact, no contact through third persons, no contact by phone, by computer, on the internet, through social media. No contact simply means no contact. If there is some brief contact in public, in a public place, you are simply to go the other way. As soon as you see them, as soon as you recognize that person as a person that you cannot have contact with, you must break off and go the opposite direction. If you live in the same building as, that means you may not speak to them, you may not go to their house, you may not do anything as an assertion or a statement or an action towards them, but you may simply go to your room or your apartment and leave or go back into your apartment as soon as you see somebody else that you know that you're not supposed to have contact with. Once you are leave the jail, you're also within 24 hours contact Community Corrections, and the phone number for that will be given to you by the jail. Do you have any questions about anything, Ms. Baumgartner?
No, I don't have any questions. I won't be able to pay the bond until the 3rd, so that's where I'm at this time.
All right.
Now, how would I go about doing this? Would I have to have somebody to go to my banking institution and get the money and bring it in, or how does that work?
That's up for you to make those arrangements. The court can't do that for you. I would note for the jail's purposes, you probably have already done this, but I have a note from my staff that fingerprints need to be taken on this matter as well.
I believe they've been done, Your Honor, but I'll look into it.
Awesome. Thank you very much. We will now turn our attention to the probation violation matter.
Do you want to address the 21-day rule since you're gone the next 2 weeks?
Well, I'm gone for 2, but I'm not gone for 3.
21 days would be. Okay.
Mr. Brown, what we're trying to do is make sure that we're not in violation of the 21-day rule for the prelim. So I'm setting that for the Wednesday of the week that I get back. That'd be April the 1st. And there'll be a felony status review on the Monday morning following that, or preceding that, which would be March the 30th. Just if you are appointed as the attorney, just for your consideration.
Okay, thank you, Judge.
All right. Now we'll turn our attention to the probation violation matter. Ms. Baumgartner, this is file 25-44031-SM. You're on probation in this matter for a mail theft charge. You were sentenced on December the 22nd. The allegation is that you were charged now with new criminal offenses, which I've just read to you. 2 counts of mail theft, and that the recommendation is that you serve 93 days in jail and that you be discharged from probation with fines and costs preserved. On a probation violation, you have the right to have a hearing. That would be in front of a judge. It would not be in front of a jury. You have the right to see, hear, and question the witnesses against you. You have the right to present your own witnesses and evidence and get a subpoena from the court to require those witnesses to appear and testify. You'd have the right to testify yourself or to be testify yourself or to remain silent, and that silence could not be used against you. The burden of proof by a preponderance of the evidence, and that would be remain with the probation department at all times, and you'd have the right to automatically appeal if you had any error in that case. Do you understand the rights that I've just given to you?
I'm trying to grasp the concept of this. I'm having a hard time trying to understand it.
The concept is you're on probation for mail theft. You were court ordered to do certain things. One of those things was to not commit any new crimes. So now you're charged with, as a probation violation, having committed new crimes while you're on probation. If that's true, and if it's proven at a court hearing, you could have some additional penalties based on your probation. In other words, I could put you in jail or fine you or require community service work. The recommendation is that I put you in jail for 93 days and discharge you from probation with preserving the fines and costs. So do you understand the probation violation that's been made against you? That is new criminal charges?
I believe so.
Do you understand what the recommended penalty is? Up to 93 days in jail?
Yeah.
All right. I'm going to enter a not guilty plea on your behalf because I believe it would be appropriate for you to speak with your attorney. That'll likely be Mr. Brown, and maybe he can attempt to resolve both of these cases at the same time, or at least work an agreement out. But we'll want to give him the opportunity to do that. Because you qualified for court-appointed counsel in the last case, I'll find that you qualify for court-appointed counsel in this case, and we'll allow that time for that to occur. We'll hear this again on that same April 2nd date. Afternoon on April 2nd.
Yes.
So we'll set it with the felony case for April 2nd at 1:30 p.m. All right, do you have any questions about that, Ms. Baumgartner?
No, I just want to talk to my attorney, which I will be soon, so.
Yes, he'll make arrangements to meet with you as soon as he possibly can. Anything else, Mr. Brown?
Just one thing, Your Honor. Is there going to be a bond set on the probation case file? I would, because of the previous matter and a relatively high bond, I would ask the court, just for purposes of credit, to set a nominal bond in this particular case.
Yeah, I think that's appropriate. So I'll set a cash surety 10% bond of $1,000, which means that she would have to post $100. So on this probation violation, Ms. Baumgartner, there's a bond that you'd have to post of $100, which would be in addition to the amount of bond in the felony case. What that does is that assures that you get credit for any time that you're currently sitting in the jail against any potential jail time. So it actually works to your benefit. All right, that's all for today then. Thank you very much.
Thank you, Judge.
Okay, I'll pay the $100 bond then.
No, you're not
Talk to
understanding.
talk to your attorney first. The issue is if you're sitting in jail and you post bond, then you lose, or you wouldn't have credit for the time that you sit already. If you stay there now, you may get credit, but your attorney, Mr. Brown, will explain that to you in greater detail to help you understand it better. That's all for today. We're in recess.
We will go on the record in the matter 25 CF 167 State of Wisconsin versus Alan Belisle Jr. This date appears through District Attorney Kevin Schmidt in person. We have Mr. Belisle in person with his counsel, Michael Becker. We're set here today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. Becker, can you please recite it on the record?
Your Honor, Mr. Belisle is going to enter a plea on count 1 and count 2. The parties are jointly recommending that Your Honor withhold the judgment of conviction as it relates to count 1 and approve of the DJOC document that is attached to the plea questionnaire. It is for a period of 12 months. It has affirmative requirements, obviously commit no new crimes, but to complete an AODA assessment by a state certified provider. And do so within 90 days. And to obviously inherent with that, remain on bond. He has certain bond conditions related to sobriety, absolute sobriety. As to count 2, the parties are jointly asking this court to order 10 days of jail. And I'm going to ask the court to allow 60 days for him to report on that. I will note he'll, I think, end up doing it before the end of this month due to work reasons, but just asking for that grace period. Counts 3 and 4 to be dismissed with prejudice. And the only other thing is to have restitution remain open at this time. There has been a restitution request made. I've received some documentation. Attorney Schmidt and I have discussed that. He's attempting to get more documentation from the victim. If it all pans out, I don't see an issue as to the amount. We're just looking to verify that amount. That's all.
Victims' rights compliance.
Yes.
Is victim going to make a statement here today? No. All right. Okay, so I'm willing to hold open restitution for a period of time. 30 days enough, or do you need more?
I am confident I get done way less than that.
Okay, I'll hold it open for 30 days. If I don't hear anything other than getting an order to sign for stipulated restitution, then I am going to, and we won't have restitution because I'm only holding it open for 30 days and I'm not going to set a hearing.
Understood.
But if we are going to need to have a hearing, just let the court know and we can get that scheduled. All right. So I have in front of me a plea questionnaire waiver of rights form, as well as the deferred judgment of conviction document. Did your attorney go over these documents with you?
Yes.
Did he go over them thoroughly with you?
Yes.
Did he essentially go over them word for word?
Yes.
And you understand everything completely?
Yes.
If you didn't understand something, did you ask him to explain it?
Yes.
And he did so.
Correct.
Did you sign both of these documents?
Yes.
So you are pleading guilty to 2 counts. One is a felony count, strangulation and suffocation, and one is a misdemeanor battery. Is that correct?
Yes.
You're 44 years old. You have 12 years of schooling. You can read, write, you understand the English language, no drugs, alcohol, or medications in the last 24 hours, no mental illnesses or disorders, correct?
Yes.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney thoroughly go over with you the maximum possible penalties you face?
Yes.
Attached with both of those documents are the jury instructions for the crimes. And he thoroughly went over those with you?
Yes.
So you understand everything completely.
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on both of those documents on the first page. Did he thoroughly go over those rights with you?
Yes.
And do you understand them completely?
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand? So you understand those rights, but do you need me to go over those rights with you in any more detail?
No.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Now, do you understand that if the court does accept the deferred judgment of conviction, this next, the next requirements will not go into effect, and they won't go into effect unless the court enters judgment either through this deferred judgment of conviction or today. So do you understand that you're charged with a felony, and if judgment is entered, you would no longer be able to possess or own a firearm?
Yes.
You would no longer be able to vote in any election until your civil rights are restored.
Yes.
Now, Here, the state would have to prove for count 1, strangulation and suffocation on or around November 23rd, 2025 in Burnett County, Wisconsin. You intentionally impeded the normal breathing by applying pressure on the throat or neck of another person. Do you understand what the state would have to prove?
Yes.
Do you understand for that class H felony that upon conviction, you could face a fine of up to $10,000 or imprisonment of up to 6 years or both?
Yes.
As to count 2, misdemeanor battery, the state would have to prove the same date, the same time, the same place. You caused bodily harm to NS by an act done with intent to cause bodily harm to that person without that person's consent. Do you understand what the state would have to prove?
Yes.
Do you understand that the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
Now, your attorney placed the agreement reached with the state on the record. Do you understand that agreement as it's been reached?
Yes.
Do you understand that I'm not bound to follow that agreement? That means I could sentence you all the way up to the maximum possible penalties for both of these crimes, and I'm not required to accept a deferred judgment of conviction. Do you understand that?
Yes.
Do you still wish to proceed and enter guilty pleas?
Yes.
Did you go over that criminal complaint with your attorney, and in particular, a section called the probable cause section, where it basically says what happened that day and why you were charged with these crimes?
Yes.
For the most part, and I do understand that alcohol was an issue or involved here, but for the most part, are you admitting that the facts are accurate?
Yes.
Mr. Becker, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, as well as the preliminary hearing that was conducted.
Thank you. Are you pleading guilty to these crimes, Mr. Belial, because you are guilty of these crimes?
Yes.
All right. Now, has anyone made any threats or any promises to you for you to plead guilty to these charges?
No.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he looked at the discovery and the evidence and discussed it with you?
Yes.
Have you discussed the facts that you know to exist with your attorney?
Yes.
Has he discussed with you a potential for any legal defenses or a lack of defenses?
Yes.
Have you discussed with him, again, any defenses that you believe could exist?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No.
Then as to count 1, strangulation, suffocation, a class H felony, how do you wish to plead?
Guilty.
As to count 2, misdemeanor battery, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of both of those counts. The remaining counts and any open matters will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered as to count 2. As to count 1, the court will allow parties to be heard. Mr. Schmidt, we are in victims' rights compliance, no victim impact statement to be made here today. So argument and sentencing recommendation.
Judge Alan Belial is a 44-year-old man with no prior criminal convictions. The only criminal history he has is in 2008 and 2010. He had DCs in Burnett. One was not violent. The other seemed to be a reciprocal event with a significant other, where reading the criminal complaint seems the other person initiated it. In this case, this happened many years later. In these circumstances, you can see the level of intoxication of Mr. Belial on the body cam. He was in a woman's room on her bed, and the officers took a great deal of time to even convince him he wasn't in his room in his house. That's the level of intoxication. He couldn't really stand or walk. It was troublesome getting him down the stairs at all. In Wisconsin, thankfully, we're a state where intoxication can't be a defense to criminal culpability, but it's incredibly relevant when figuring out the sentence, how to prevent it in the future, how to protect the public, how to make sure it doesn't happen again. That is why I've structured this as it is. The DJOC has the AODA requirement. That's 100% what's needed in this case. I think there's no doubt about it. This isn't a domestic incident. The victim doesn't even really know Mr. Belial that well. She was just giving a friend of a friend a place to stay when he was clearly extremely intoxicated. There was no inciting incident. Essentially, he was there sleeping. He was so intoxicated, he got up, started hitting the wall. She told him to stop. He stopped once, did it again, came back. That's when he choked her. That's when he attacked her. The reason why we're still getting the conviction and doing the 10 days jail on this is because the way this impacted the victim is so severe. It's just necessary in this case. It's necessary that this be the first conviction for Mr. Belial. It's necessary there's some incarceration. The reason she's not here today isn't because she doesn't care about the outcome of this case or didn't impact her enough to give a statement. It's because it impacted her so much. I won't go into the details, but she's affected emotionally and psychologically a great deal and still is to this day. That's what I'll leave it to on that. So I think that this accomplishes all the purposes of sentencing. I think that this accomplishes punishment with the jail sentence and not depreciating the seriousness of that with the jail sentence in conjunction with the conviction, the first conviction he has. So going forward, somebody asks if you've ever been convicted of the crime. The answer is now yes. And then also the DGOC making sure that we accomplish the rehabilitation and public protection objectives by making sure this doesn't happen again. It was obviously caused by alcohol. He had no motive to attack her at all. So I'd ask the court to follow this agreement. Thank you.
Is that why restitution is, one reason why restitution is being held open? Is she seeking any kind of trauma services?
No, the restitution is immediately after this. She was affected so much emotionally, she couldn't go to work for the week afterwards.
And that was around Thanksgiving, if I'm recalling.
Yep.
correctly.
So she gave us the time card, which shows the time they did pay, but we need the work schedule to show she was actually scheduled to work there. So I didn't realize that until Mr. Becker emailed me, and it was too late to get that from her today.
How, in the state's view, will Mr. Becker have the oversight to control his alcohol intake with the DGOC?
Mr. Belial.
Oh, sorry. I'm sorry,
You're
Mr. Becker.
Totally good. Just wanted to
BBs.
make that clear.
No, I'm
100%.
totally okay with your alcohol intoxication, but Mr. Belial, I'm sorry. With the deferred judgment of conviction, what oversight is there going to be to ensure that he is not only getting that AODA assessment, but that he's controlling his level of intoxication?
Well, the AODA assessment, there's benchmarks in the DGOC by when he has to do the assessment and do the treatment, provide proof to us. So if he doesn't do that, I mean, it's on him to prove that to us. So that would trigger a filing of a motion to revoke the deferred judgment conviction. If you're asking if there's any testing built into it, there isn't anything like that, no.
All right. And is there absolute sobriety in the deferred judgment?
I believe it's a condition of bond. So I didn't put it as that.
All right. Gonna pull up bond. There is an absolute sobriety condition. There would have been in that he would still be under bond for a period of 12 months. So, all right. Mr. Becker.
Thank you, Your Honor. I agree largely with the context and the things that DA Schmidt has said. Mr. Belial is 44 years old. He works for Zeman Construction as a field superintendent, so he's employed full-time gainfully. He supervises construction projects, loose term, in the Twin Cities metro area predominantly, but it spans on this side of the river sometimes too. As DA Schmidt indicated, he has no prior criminal record. There are the two things that are quite dated, 08 and 2010, which didn't result in any criminal convictions. The incident here is outlined in the complaint as reflected in the body cam. There's no question that alcohol was at play. In addition to that, Mr. Belial was taking a medication in a new dosage, and so there was a mixture that he hadn't experienced before.
What medication? There was nothing listed on the plea questionnaire.
At the time, not now.
Not now?
He's not taking it now, no. And it wasn't for a mental health issue or anything like that. But I believe because of the dosage and the amount of alcohol that was present, there was an interaction which he hadn't experienced before. As a threshold issue, the amount of alcohol present was high in and of itself, right? And so obviously not an excuse by any means, just factually what happened here. The facts as they exist, which led to what happened. The agreement that's been structured, the agreement that he's accepted, has him taking responsibility for his actions that night at the most severe charge that he's charged with and at the second most severe charge that he's charged with. I think it is a measured agreement in terms of what is required of him. I have always described DGOCs as probation light to people. It's the same thing. You have conditions you have to follow. If you don't follow them, you get in trouble. That's what happens on probation. The difference here is you're betting on yourself. You have something at stake, and that is not being a convicted felon, which is a high benchmark for somebody who today, as he sits here, is getting his very first criminal conviction on a misdemeanor battery. And so Mr. Belial is betting on himself to be successful, to do what he needs to do in order to demonstrate to the DA's office and to this court that he is a quote unquote healthy and productive member of society, and that what was outlined in this complaint as of happening November 23rd, 2025 is not his normal, nor nowhere near his normal. It's an anomaly, a big one at that, a severe one at that. No one discredits that. No one argues that. I think pairing the DGOC with 10 days jail is the carrot and the stick, right? Case law tells us that probation is the first thing that you look at. That's why I referenced the DGOC being probation light. We can call that good right there on the DGOC. And then we're looking the next step further on the jail, right? It demonstrates to Mr. Belial what happens if you're not successful. Because if he's not successful on the DGOC, he's likely, the state will do what the state needs to do. He comes back in front of this court for a sentencing hearing where anything is fair game, probation, jail, or prison. It's all there. And as a former ADA, now defense attorney, I've seen many of those. And we can all agree that probation is a tough sell on the revocation of a DJOC. It's not impossible, but it's a tougher sell. So the jail is kind of a warning shot across the bow, so to speak. Overall, I think this is an appropriate resolution when we look at the facts and the circumstances. This incident clearly demonstrates through the videos and the testimony, Mr. Belial was not in a headspace where he was interpreting things appropriately or positively or accurately. He was not the most cooperative person in the world with law enforcement. It's because of how intoxicated he was. Again, that's not going to fly to 12 members of this community, but that's the underlying issue. So we addressed that through the AODA, and that will hold him responsible. I did forget to mention this off the top, and I apologize. And it goes to the conversation we've been having about bond. I 100% agree that the absolute sobriety condition should exist. We do not argue that that's should come off. I only wanted to discuss the following condition, that he can't go to any bars, taverns, or pubs. One, from a work perspective, he may have to work in those areas through his construction job. And two, he runs a volleyball league in the summers at Wood Hill Bar and Grill out of Osceola. He'd like to keep doing that. He plays in it. He runs it from a logistics standpoint. Now, the interplay of that is we understand alcohol is an underlying issue of what happened here. He understands that by making this request to the court, he's basically putting the court and the DA's office on notice that if you grant that request, he's going to be at that bar and grill for this volleyball league. So,
or he misses it for a year.
That too. I just mean if you grant it, people's instincts are up. They know what he's doing. There might be more oversight as it relates to that, right? And so he's confident in his ability to withstand any pressures or any inclinations. Also with an AODA and whatever treatment comes with that will help him through that to be sober, stay sober. And so that is another request that we wanted to make from that aspect. But overall, that is my argument, Your Honor. I'd ask that you adopt the joint recommendation, as I believe it's appropriate and measured here.
Thank you. Can you repeat what he does for work? Because you said he goes on the other side of the river.
He's a field superintendent for a construction company. So he, I think we can liken it to a project manager, foreman type. He's overseeing these jobs.
He's the boss.
On site, yes.
Okay, so you're not doing the construction unless you're showing them how to do it?
Yes.
Okay. If you have an ability to be somewhat flexible in your job?
My understanding, and he can verify, is that he's assigned job duties or locations to do projects. He doesn't get to do the assigning of the ones he goes on.
No, okay, but if you're, do you have a flexible week where you could say, I'm gonna be honest, I'm gonna be telling you, I'm contemplating adding a requirement to the deferred judgment of conviction to do one of our restorative justice programs. Because I think it will help you, not only with what happened, but it will help you for the future with the unknown that the court has. Because I don't know you. This is the first time I ever met you, first time you've been in court. I don't know if you do have an alcohol issue or a substance abuse issue. I don't know any of those things. You do, or maybe you don't because you've not been able to totally self-reflect. And so that was my thought, because I think you would get a lot out of it. I think you would really like our restorative justice coach, Dave Hatch. He's great. He's great in a whole lot of other things, and he can help you, or you might just like him and learn a lot. And so that's what I'm wondering. Do you have the ability to be flexible? It would be for a period of 4 weeks. And so I'm not sure your work hours, your work schedule, those kinds of things.
I guess I don't understand where I can leave work early, or I guess.
Right,
not.
or leave work early, or be able to go in late one day or something of that nature.
Yeah, there's some flexibility there. It would just kind of depend on what job I'm on at the time and what state of the project we're in, where there's times you don't have to be there for inspections and meetings with
Right, and it would,
clients and stuff.
it would be something you would work out with Mr. Hatch of when you're able to fit it in and to do it. And he does travel some too.
Okay.
So you can meet halfway
Yeah, I guess.
or something. Okay. All right. Mr. Schmidt, as it relates to anything stated with the bond modification request?
As it relates to what they're saying now.
Okay. All right. Mr. Belial, anything you want to let me know, you want to tell me, or was there anything else you wanted to say, Mr. Becker?
I think I said my piece. Thank you.
Okay, Mr. Belial.
Just that I apologize to both Nicole and the sheriff department on my behavior that day. It was, again, not like me. Just honestly completely embarrassed about it. I have no doubt in my mind that if you adopt the JOC in this plea deal, that I will complete it 100%. That is no question in my mind. That's just too much to lose if I don't. And yeah, I just apologize to everybody involved about the whole thing.
So, Mr. Belial, prior to this incident, would you say that you had some issues with alcohol? Let's be fair. I know a lot of construction people, and I know that some of them like to partake.
A problem? Honestly, no. I don't drink if I have to work the next day. I only have some socially on the weekends. No, but they're not hard for it to spiral out of control on a given night.
It could spiral out of control?
It wouldn't take much.
Okay.
Not that it's happening often, but
Anything else you want me to know?
not at this time.
All right, thank you. What I get to know about the case is what is in the criminal complaint and what the individuals tell me, or what impact statement I hear from any victims involved. So what I have in front of me is simply what's stated in black and white in the criminal complaint, again, with the arguments. I think everybody here admits, even you, Mr. Belial, this was a very serious matter. And it rose to a level of violence. Maybe that's in your nature, maybe that's not in your nature. I don't know you, again, from Adam. This is the first time I've seen you. You're from Osceola. You're from a different county. But from your criminal history, which is very sparse, it appears that you follow the law, or you usually do what you need to do, and or you haven't gotten caught. But if it relates to violent episodes, other than the ones that were from 08 or 10 or whatever those are, Mr. Schmidt, the state's not even saying that they were extremely serious. There's something to be concerned about. This looks like it could be a pattern, and it could be hidden from 2010 to 2026. So I'm not getting that as an argument from the state. I could be, but I'm not. So I'm not going to define anyone who's in the contract or construction business. I know plenty of people, family members of mine are, but I do know that sometimes after a job or after a night, and especially if you're out of town and your house out of town, generally people go and they have a few beers or they have a few more. I don't know if you do have an alcohol issue. You did make a statement that at times you could, I don't remember your exact words, it can get out of control or get out of hand. Thankfully, it has not gotten out of hand to this level before. Otherwise, this would be a different outcome. But again, this is a serious matter. It's so serious, and it was so impactful to the victim that she can't even appear here today. For fear, I'm guessing that it would cause her anxiety to go up, all of these emotions, just from hearing what's going on, and probably from the sight of you. That makes this extremely serious, and that makes the court have to look at this a little bit more carefully. You are accepting responsibility and you are willing to be accountable. This is a crime. You're 44 years old, and now you are a convicted person. You have a criminal record. You can't get this expunged off of your record. It will be there, and it will be there as a battery on your record. There are certain requirements in the deferred judgment of conviction, and that is an additional oversight. It's not as stringent as probation. There's pluses and minuses to deferred judgment of convictions, because they are serious enough and they do have enough oversight that if you do not abide by your bond conditions and or you commit any crime that rises to the level of probable cause, or you do not do your AODA assessment and provide proof to the state, and or you don't pay your $150 within 60 days, a felony can be entered on your criminal record. It could be the agreement can be revoked and terminated, and judgment will be entered, and you will be in front of the court for sentencing on a felony, and you will be a convicted felon. That's what makes this a little bit more of a stick over your head, because I think I'm gonna guess, I don't know, you like to hunt.
Yes.
Yes. And it would be a serious penalty to you to have your firearms taken from you forever.
Yes.
And so knowing that, and knowing that you are under your bond conditions, hopefully that's enough for you to abide by the law and do the things that you need to do and follow the law to the letter instead of walking that gray line. Because not only will you lose your firearms, you're going to be a convicted felon. You could go to prison because it's a class H felony. Serious. Now, for the most part, I do think that the agreement is appropriate. There's going to be punishment with jail. Nobody likes to go to jail, especially an individual who, other than these 2 days, I don't know if you've ever been in jail, but that's going to be the longest time that you're going to be in jail, hopefully for the rest of your life. That's punishment enough. Can't order Diet Coke. You can't order a steak. You're stuck with whatever food they have and they give you, and the packet of lemonade. Okay, so that's not going to be fun. And I believe that will give you time to reflect even more on this incident and what happened. I'm going to accept the deferred judgment of conviction because it is something that is serious, and you could be a convicted felon if you don't abide by those things. I am adding the condition though, and I'm going to write it right on there, that you do the apology letter coaching, and you write an apology letter, whether or not she wants to receive it, because she has the choice where she doesn't even have to even open the envelope and read it. That could be traumatizing for her. But at least there, if that happens, she would be able to hear your remorse and anything that you want to say and apologize. So I'm going to say that you do the apology letter coaching with restorative justice. And at the same time, you do the skills directed practice. The skills directed practice, that's where you can meet with Mr. Hatch and he can talk to you about any resolution skills that you have, cognitive awareness, thinking before you act, and possibly thinking before you have the third beer or fourth beer, or even the first beer, quite honestly. And it is a program that will restore your relationships. You'll get an idea or understand the impact of the victim, and you'll be able to think a little bit more about that. And it's there so you can have a better understanding, so that you can, when not extremely intoxicated, you can respond to things that happen in your life instead of reacting. And I asked your flexibility with work because this is a 4-week program. And the apology letter coaching can be built right into that. But I am going to say that Mr. Hatch can be a little bit more flexible, and that you can work it out. So even if it takes 8 weeks, it takes 8 weeks. The important thing is that you do the class, you learn the things, you speak with Mr. Hatch, who is a previous probation officer for over 20 years. And now all he does is restorative justice, which is trying to restore. It does a whole lot of good things for the community, for people who are in your seat, as well as for victims. And so I love the restorative justice program, and Mr. Hatch is really good at what he does. And I think you're going to find him to be a really good person. And you can probably talk to him about a lot of life things. So I'm going to say that that needs to be completed. If this is going to be a year, I'm going to say within 5 months. But you do have to contact Mr. Hatch. Today is Wednesday, and at least leave a message for him by the end of the week and have him try and connect. And you can talk to him and you can say the court said this can be flexible, but he's going to get my document that says be flexible. You're going to get a copy of this too. So by August 31st. So I am accepting the deferred judgment of conviction. Again, I'm going to strongly encourage that you pay the $150 to the state immediately if you can, because that is the #1 reason I see the state asking me to enter judgment and to sentence on that felony. Okay, so take care of that right away. As it relates to the battery, I will sentence you to 10 days of jail, 2 days of jail credit, $500 in fines, fees, and DNA surcharges. I am going to hold open restitution for 30 days to wait to see what that amount would be. If it's stipulated, then I'll get a stipulation to sign. If it is not stipulated, I will hear if we need to have a hearing. Okay, and you'll be notified by your attorney. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. Again, if the deferred judgment of conviction is entered and you are sentenced on that, you will no longer be able to use or possess a firearm for life. Bond conditions still exist and they are still in place. However, I will modify bond to state that with any bars, taverns, liquor stores, casinos, as long as you can be there for a work-related purpose. Obviously, you're going to be fixing it up. You're not going to be staying there 8 hours during the day, or it shouldn't be there at night. So it should only be during the day. And as it relates to your volleyball, I do think that that's a positive thing. Granted, I know I've been on a bar league before. Sometimes it can be overly fun, but you are on a no drink. So you can do the volleyball league, but there's absolutely no alcohol. And I'm letting you know you can be tested. And if anyone sees you or thinks that you're drinking, they have the ability to call the police because that's a bond condition. They can come and they have the right to test you. Okay. So they will test you right then and there. And if you violate, then that means you will be arrested immediately and a deferred judgment of conviction will be entered. Okay, so it's very important you follow that, and don't even go like I'm at home. So that means I can have a drink. No one's going to know, because then that opens up in your brain where you're like, well, maybe one drink at the bar is fine or at the volleyball is fine. No one's going to know. They'll think it's iced tea.
Yep.
Okay.
Yep.
20 days to appeal. I stated that. If you fail to pay your fines and fees, not only will a civil judgment be entered against you, you're always going to owe it. I will issue a warrant and you can sit up to 6 months in jail. We have $500, so that could pay your fines and fees, but quite honestly, that's going to first go to restitution because the money always goes first to restitution. You're going to have to pay off that restitution and or pay off all your fines and fees, because I'm going to tell you, I don't know if you sat through the one probation review hearing I had, but I have restitution court. You will be in front of me. I have the ability and I have tools at my hand, and you could sit jail. So it's very important that you understand that and you pay. And the same thing with the court costs and fees. I need your DNA. You're going to need to go to the jail and provide that. If they have it, they'll send you on your way. If they don't, they'll quickly swab you. With the battery, you have the ability to request it be expunged through a written letter to the Department of Justice, not to me or this court, to the Department of Justice. It's easy to do. And I don't know if Mr. Becker knows how, but it's easy to do. You can Google it and very easy instructions. So either you can Google it and figure it out, or Mr. Becker can, and you guys can talk about it. But it's easy to do. With the felony, that just kind of hangs out there. And if you are convicted on the felony and I do sentence you, I'll tell you the same thing. Do you need me to go over your bond conditions with you again, or do you understand them and as they're modified?
I understand.
Okay, Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Becker?
I don't think anything, Judge.
I am missing one thing. With the report date, did you ask for 30 days or 45?
I asked for 60. I am confident he's going to end up doing it in about 2 weeks, given work scheduling, but I just asked for
Okay.
time. So.
I don't know about other judges, but I never give the 60 because you never know what's going to happen and you may need to extend it. So I will give 45 days to report that. And then you will come here, you will report to the jail. I'm going to strongly encourage that before you report, you give the jail a couple days notice. We have enough room, we have enough things, but just to make sure they have enough staff on. Because one more could mean that they need one more staff. Did I miss anything? All right, we're good to go. We are adjourned.
Thank you, Judge.
Hold on a second. Let's go off the record for a moment. Is Attorney Anderson here for Braxton Bailey?
That's what I'm aware of, Judge.
Okay, we need to contact that attorney, please. Is Mr. Bailey here? Mr. Bailey, Braxton Bailey? Is that person checked in?
Let me check my sheet here. See page 2.
Okay, so does that mean that the defendant's not here?
Yeah, if it's not, they're not here.
Okay. Can you just check with Laura to see if there's been any communication, because we have a victim here in that matter, and she's been here for quite a bit. I just want to see if I'm issuing a warrant or what's happening. And then we are on the record in the matter. My DC attorneys. Okay. Let's go on the record in the matter of the city of Wyandotte versus Samantha Firmstone, 269 A and B.
Morning, Your Honor. Edward Zelenak for the defendant. I'm substituting in for the MIDC lawyer with Ms. Firmstone. With your consent, is that right?
Yes.
Please state your name audibly, clearly, loudly to the court.
Samantha Michelle Firmstone.
Okay, good morning. So I'm confused, counsel. Are you retained?
I retain. Yeah, no, I don't do that free stuff.
You're
Sorry.
retained. Okay, just want to make sure. So I have that in here. Okay.
Nothing against they provide a valued service, but happen to know the family and
Okay.
her uncle. So they were in the hallway and I decided to step in as an angel of mercy today.
Okay. Is that 27611 or 661?
27611.
Okay.
Thank Sergeant Midlars for the use of it.
All right, and counsel, today is the date scheduled for the arraignment and the pretrial in this matter, and as to the arraignment.
Waive the reading, ask for a standard mute, enter plea not guilty as to both counts, and you understand that you're not having the charge read over in court. Is that correct? Thank you, Judge.
I can't hear you.
Yes.
Okay, very good. Thank you. Thank you for addressing appropriately for court. And the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then ask the pretrial counsel.
Judge, they made a generous offer of operating while ability visibly impaired and to take the second count of possession of a controlled substance without a prescription. Under the Holmes Youthful Trainee Act, she does qualify for both. This is her first offense. We'll stipulate to the intoxilizer score, which is substantially higher, and she's prepared to admit its authenticity and provide a factual basis for the plea of both counts. And Judge, I forgot what it was about a 24. I don't see it on the ticket.
Okay. And so the possession of controlled substance, that's under HIDA, correct? All right.
And it was Adderall. We'll attribute the accurateness of the test.
All right. There also, just so you know, counsel, were some letters of recommendation sent to the court on behalf of your client, but I have not reviewed those, and I will defer reviewing those until sentencing.
I agree. That must be something they pick up on AI now, Judge, because I certainly wouldn't do it before I end up in court. And I notice every young person I've had here under the age of 30 has done that before we got to court. So I explained to her that probation will look at them and the court will address them after probation sees them. Thank you, Judge.
All right, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. And you heard the plea that was placed on the record, correct?
Yes.
As to the amended charge of count A, that being operative visibly impaired, how do you plead?
Guilty.
As to count B, possession of controlled substance, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
You understand possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes, ma'am.
You understand what the HIDA status is.
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, ma'am.
Any immigration issues?
No.
Counsel, if you can please avoid your client.
All right, ma'am, on January 1st of 2026, New Year's Day, approximately 2:07 a.m., you were pulled over by the Wyandotte Police Department. Is that correct?
Yes.
And prior to being pulled over, you had consumed intoxicating beverages celebrating New Year's Eve, whatever the event was. And you would guess you had at least 7 alcoholic beverages as far back as you can remember. Is that correct?
Yes.
You believe they affected your ability to drive a motor vehicle in the city of Wyandotte, County, Wayne, and state of Michigan. Is that correct?
Yes.
And you were told you had obstructed mirror and obstructed vision, and that in part led to you swerving and driving to attract the attention of the Wyandotte police officer, and that was Officer Salzman.
Yes.
And you believe the alcohol played a part in that. You don't contest the results of the intoxilizer or the portable breath test on the road.
Yes.
And you recall that it was around a 24, but Judge, it's not on the ticket, so
It was a .224.
we were close. All right, and you realize that's almost 4 times the legal limit, 3 times
Yes.
the legal limit for drunk driving. You've been offered impaired at county. We've been impaired your ability to drive.
Yes.
And when the police asked to check your vehicle before they towed it, they found Adderall in the center console.
Yeah.
You knew it was there.
Yes,
You do not have a prescription for Adderall.
no,
And you're under the age of 25.
yes.
Okay. The court is satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the charge of possession of controlled substance and the amended charge of operating while visibly impaired. We will determine your eligibility under height of status at sentencing. Counsel as to bond.
She posted a $500 bond. She's been here today, and I don't think there's any reason to ask for anything else, Your Honor, unless you have some reason. Did you ever fail to appear in court, ma'am?
No,
If you were tested today, what would be in your system?
absolutely not.
No wax pen, weed, or anything?
No.
All right. And you're not on probation or parole anywhere?
No.
You're not out on bond in any other jurisdiction?
No.
Okay.
One last thing I want to make sure you understand, because you had Adderall. No prescription. You know that the stuff they sell at the gas stations, you can't drink that or take that either.
Yes.
Yes, thank you, counsel. All right, and so the court will order your cash bond to continue. And you're not to possess or consume any alcohol or drugs that are not prescribed. And the court's going to order you to participate in random testing based upon the charges and the level of alcohol in your system, ma'am. The court has an obligation to ensure the safety of the community is as safe as it can be. So you're going to get a copy of your bond conditions when you go over to probation. You're going to get all of your next steps as well. Okay,
Judge, thank you.
thank you. Have a good day. We're on the record. Where's okay, do we hear, let's go off the record. Do we hear anything back from,
I sent Gordon. Dolores,
okay,
nothing back yet.
okay. Miss Henderson, there's Miss Henderson. Okay, I know that you've been here for a little bit. We're just trying to figure out if there's been communication from Mr. Bailey or his attorney, because neither one of them are here right now.
I've seen them out front.
Mr. Bailey or his attorney? Oh, he has not checked in.
Yeah, he's Bailey's here, but the attorney isn't.
Oh, okay, so he's here. Then,
Anderson.
okay, then we need, actually, do you have the attorney's phone number, Kelly?
Yeah.
Oh, she's calling the attorney?
That is.
No, I just want to know if she had heard anything from the attorney.
I'm gonna call him.
Nope, I'm going to call. What's the number?
313.
Mhm. Okay. Oh, can you give me my phone, please? If you want to dial it, that's fine. 313.
What?
Yeah.
What'd you say?
It's Attorney Anderson.
Right, is the first name Emmett?
No, James.
James. Oh. No, this is Judge DeSanto. I'm wondering where Mr. Anderson is. This was scheduled for 9:15. It is 10:37. Okay, well, I have had a victim sitting in this courtroom since before 9:15 a.m. And it's not acceptable for Mr. Anderson to not be here. An hour and 15 minutes, an hour and 27 minutes after the time that he was scheduled to represent his client in sentencing. So Mr. Anderson needs to be here ASAP or he will be held in contempt. Thank you. All right, bye. I'm not showing up, show up and not communicating with the court. Okay. Oh, we're not to this thing. Yeah, Mr. Serrano in here.
You haven't called my case while I was at the tip.
I did not. Nope. I was contacting an attorney that's not shown up for an hour and 25 minutes.
Oh, that's not me for sure.
All right, let's go on the record in the matter of the state of Michigan versus Braxton Bailey, 6-4. Is Ms. Henderson still present?
Unfortunately, with Mr. Bailey's attorney being late, she had other engagements she had to go to. Unfortunately, she will not be here to see the justice received.
All right, I was unaware that she had to leave.
Yeah, she's been here approximately 3 hours.
All right, yes, I'm very much aware of that, sir. Thank you. All right, counsel, your appearance, please.
James Anderson, appearing on behalf of Braxton Bailey, Your Honor.
Mr. Bailey, your name for the record, please.
Braxton Bailey.
Okay, and so counsel, I addressed this slightly when you zoomed in, but this matter was scheduled for 9:15. We had a victim that's been here since 9 o'clock on a very violent case. And there was zero communication with this court. At some point, you realize that there was a time conflict, correct?
At some point I did, Your Honor. I had a matter scheduled in the circuit court for 8:30. I decided to go to that matter first, hoping that I would have enough time to not be so late in this court. Unfortunately, it did not work out the way that I planned. I understand and I apologize for not contacting the court to let the court know that I was being detained and held back.
Okay, well, counsel, clearly, if you had an 8:30 circuit court matter and a 9:15 matter here, you were never going to be here at 9:15. There was not even a possibility of that even happening. And you did not even contact into the court. Zero regard for the court time, zero regard for the victim time, and zero regard for your client's time. And even after you were here, after 9:15, you didn't even contact the court until this court contacted your office multiple times. Only then did you contact into the court.
Again, Your Honor, on some of the matters I was on the record, most likely, I did hear my phone buzz while I was on the record in court. As soon as I was able to get out of that, I contacted my office. And then I immediately, as soon as I was able to contact the court, and if I zoomed in to see if I still needed to show up in person. You know, oftentimes in the circuit court, I've appeared on matters at 8:30 and they've been finished in enough time for me to arrive here in court on time. Unfortunately, it did not work out this morning. Again, I apologize for not letting the court know.
All right, well, and the court can understand that, counsel, and the court can understand the demands on an attorney's schedule in multiple courts, but the court cannot understand the lack of communication. So the court's going to order a $100 sanction, counsel.
I don't know. Since the court is well aware that the circuit court takes precedence over matters in the district court, again, I apologize for not contacting the court, but I don't know that a fine in that regard would be appropriate.
Counsel, you didn't communicate with this court at all. This court had to contact your office multiple times, and that was over an hour and 20 minutes after you were scheduled to be here. Your client was sitting here without communication. Your client also has been sitting here now for almost 3 hours. The victim was here without any communication. There is zero communication. If you would have contacted the court, counsel, via email, even yesterday or Monday, the court could have made some arrangements and notified the victim and your client. We could have adjusted the time that you needed to be here, but that didn't occur. And there should have been communication with the court, and there was none. So the court finds the sanctions appropriate. And now we don't have a victim here to speak on her behalf, as she had prior engagements that she had to tend to, it appears. Sir, your name for the record, please.
Shane Boyd, I'm her stepfather.
All right, can you spell your first and last names, please?
SHNLLOYD.
Okay. And was Ms. Henderson intending on addressing the court today?
Unfortunately, now she's not able to.
That wasn't my question, sir. When she was here, was she intending on addressing the court, or was she here simply for observation?
I believe just for observation.
Okay, thank you. Yes, Court Officer Midlars.
She just spoke to you. She advised me she did not want to address the court.
Was that your phone on?
There's an alert.
Please make sure it's on silent. I'm sorry, what was that, Court Officer Midlars?
The victim assured me that she did not want to address the court, but she wanted to see justice prevail.
Okay, thank you. Okay, so counsel, I asked those questions to determine whether or not we can proceed or if we needed to set it for another date, but we will proceed since Ms. Henderson was not intending on addressing the court. She was here for observing the sentencing. And so counsel, today is the date scheduled for sentencing on your client's plea to domestic violence aggravated. The felony of assault with intent to do great bodily harm less than murder was dismissed by way of resolution between counsel and counsel. Do you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor, I have reviewed the report and recommendation with my client. The only correction to be made is on the criminal history. It says the defendant has 5 warrants. We don't exactly understand what those warrants are. I do understand he does have some traffic matters. He presented to me this morning receipts from payments from the court on those traffic fines.
Okay. And
That's what those were.
all right, sir. Where did you make those payments? And I'm sorry, when did you make those payments?
I want to give you the right date. These payments was made on February 26th.
Okay. So let me just go through because I'm showing it as of March 6th. This is what is showing. Warrant out of 18th District Court in Westland on October 2nd of 2024. That is for failing to appear for a show cause hearing via Zoom on a plate violation that apparently wasn't paid. The other warrant is May 7th of 2025 out of the 28th District Court. You failed to appear for an arraignment on a drug license suspended. September 15th of 2025 out of 19th District Court. There was a bench warrant issued for failed to display a license, and you did not appear for the bench warrant hearing. Then January 26th of 26 in the 22nd District Court in Inkster indicates that you failed to appear for a show cause hearing that you had for your speeding ticket that apparently you didn't pay. Also, red light ticket out of the same court, the same week. We had a show cause hearing and didn't show up. Are those any of the places that you paid tickets at, sir?
No.
Okay, so those are the 5 warrants.
Thank you.
You're welcome.
That's not bad. I haven't had any mail. I haven't seen any mail.
So, sir, I did take that into consideration with your January 26th one, right? The date of the warrant for January 26th. So I don't know what date that show cause hearing would have been scheduled. It doesn't indicate that. It just shows the date of the warrant was January 26th. The court did note that when I was reviewing the sentencing that you have not been back at the home since you were arrested on December 25th of 25. So whenever, I don't know when that one was scheduled, right? But now you're on notice that you have the warrant out of Inkster and because you didn't show up for a show cause on a ticket that appears from 2021 that you owed fines and costs on. The other matter, sir, the court would presume that it was sent to the address you've been residing at. Those are all prior to December 25th. All right. As to sentencing counsel.
Aaron, I asked the board follow the recommendation. Since recommendation rather than.
Sir, I need to tell you that when I was reviewing this matter, the actions that you exhibited that day made my stomach turn. You punched Miss Henderson, with whom you have 4 children, correct?
No,
No, 1 child?
3.
You have 3 children.
Yes.
1 child is not yours?
Yes.
Okay, is that the 5-year-old?
No, I believe he's 6.
Okay. So you have 3 children with Miss Henderson, one of which is 8 months old. And I believe she had just gotten back from the hospital with the 8-month-old, correct?
Correct.
Right. And it's Christmas Day.
Correct.
Right. And so the allegations are that you choked her, threw her out of the chair, you punched her in the face so hard that her tooth was knocked out. And then you hit her in the head with a trash can. And in fact, one of the statements that I reviewed was that you were holding her with your hand by her neck. And then you punched her in the face.
That's not what happened.
Sir, the fact that you put your hands on her at all is a problem. The children were present.
That's not true either.
The 8-month-old wasn't present?
No,
None of the children were present.
no,
Where were the children?
with her mom.
Yeah,
Opening presents that morning.
yeah, if I may state that the original charge was assault with intent to do great bodily harm less than murder. If the prosecution was certain of those charges and that they could make out a factual basis, I don't suspect that he would have been offered reduced charge of aggravated domestic violence.
That wasn't reduced charge, counsel. That was count 2. You pled to count 2. They dismissed count 1 at the exam.
Well, I'm sorry, Your Honor, still.
And counsel, what does that have? What relevance is that as to what this court is stating as to the allegations?
At this point, it's not relevant.
Okay. Of the 4 children, sir, are those boys or girls?
We have 2 boys and 1 girl.
Okay. And so what if somebody assaulted your daughter like that?
I'd rather not answer.
How'd you get here to court today, sir?
Uber.
How do you get back and forth to work?
I have my friend, one of my coworkers, pick me up, drop me off.
And what do you do with this program that you're involved in, sir?
Which program? The Boys to Men program is a nonprofit from my church where we take 100 to 50 to 100 young men and we basically just give them life skills, chivalry. We show them how to change a tire. We build a wall. We show them how to tie ties. And me being a member of the church since 2010, I'm like a big brother to a lot of these younger men.
Okay, you said chivalry.
Yes, ma'am.
Okay, but what does that mean to you, sir?
Chivalry isn't dead. It's not present.
What's that?
Says chivalry isn't dead, it's just not present.
Okay, so what does chivalry mean to you, sir?
It means a lot. Manners, how to treat a young lady, opening doors, pulling out chairs.
Right, not knocking them off of chairs, right?
Yes, ma'am.
Right. So how are you helping young men learn how to do that when you are here on your aggravated domestic violence charge conviction?
I know the skills. You know,
You just have difficulty implementing those skills for yourself?
at sometimes, yes.
All right, the court's going to note that after hearing from counsel, hearing from Mr. Bailey, reviewing the report, the recommendation, reviewing the police report, the court does find there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Bailey and the legislative guidelines. Sir, if you're going to test right now, what's in your system?
Nothing at all.
The court's going to order 24 months probation. You're not eligible for early discharge. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. Do not use any alcohol or drugs unless prescribed and be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are going to have to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition serves so you can have assistance in providing coping mechanisms so you can maintain sobriety and prevent relapse, hopefully preventing this matter from happening again. You are not to have any contact with Ms. Henderson. That's phone contact, text message, email, social media, third party, anything of the like. You are not to return to their home on Ray Street. Obviously, the rehabilitative condition for those conditions is so there's the victim there can be safety for the victim and the minor children. You're not to possess or have access to any firearms or weapons. Do you have any of those, sir?
No.
You are to participate in a 26-week domestic violence counseling program. The rehabilitative goal for that condition is so you can further increase your understanding for responsibility of your own actions to educate you about how to change or modify your behavior when you're in a situation that upsets you, sir. There's been $0 requested for restitution. You're not to drive without a valid license. The court's going to order mandatory jail for any violation. The court's going to also order 45 days jail. I will suspend 40 of those days. You're going to serve 5. Any questions regarding those conditions that this court's put forth?
Your Honor, did you just state that that is to serve 5 days in jail?
Yes. I will give him a report date. He doesn't have to go right now.
And also, I did not compute credit for time, if any, that he served thus far.
Well, I'm not sure. Let's see, he posted his bond. I show a bond of on January 14th. I don't know when that bond, I don't know if that bond was nope, I'm showing January 8th. It was posted.
No, the bond was raised to, I believe, 20,000, 10% at some point.
Well, it was. So your client at the arraignment, the out county magistrate at the 36th District Court found it appropriate for a $5,000 personal bond on December 27th. Then this court amended bond on its own motion on January 8th, which your client posted on January 8th. And so your client would have credit for 3 days jail, 25th, 26th, and 27th of December. I would give your client credit for 3 days.
Thank you.
I'll have your report Friday, March 13th, sir. Any questions?
Yes, can I have some type of paperwork to give to my job as far as this weekend?
Yes, you can get that from probation.
Your Honor, made a television at well, now or at the report time?
Court will indicate the tether can be removed at the date that your client reports to jail.
Thank you.
Sir, just so that you're very clear, you are facing up to 1 year in jail. If there's a violation of probation, sir, or if this court revokes probation because you cannot follow the terms and conditions of probation, you're looking at up to 1 year incarceration. I certainly hope, sir, you're able to get it together so that you are not behaving in this manner again. This is the mother of your children, 3 of your children, and this is how you treated her. Reprehensible behavior. The court's going to order as far as the fines and costs go. The court's going to order a $500 fine, $100 screening assessment fee, $1,200 supervision oversight fee. That's $50 a month at 24 months. $300 for cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. That's a total of $2,225. You did post your bond, so that can be applied, sir. There was a 10% retention per statute, which would leave a balance of $1,800. That can be applied. It leaves you a balance of $425, so you can coordinate any payment plan with probation. All right.
Yeah, look.
Any other questions, sir?
Nothing, thank you.
All right, thank you. Have a good day. And counsel, you can stop at the window as well and pay your sanction. Let's go off the record for a moment. I have to. Okay, Mr. Mandel?
So.
Yes, Judge. Sorry.
You're not driving, are you?
No, absolutely
Okay.
not.
Very good. Okay, we're on the record in the matter of the state of Michigan versus Dennis Rohde, 26305. And Sergeant, your name for the record, please.
Sergeant Stephen Oborn, Oborne.
All right, thank you. Please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. And if you can please proceed on the warrant.
On March 10, 2026, at approximately 21:03 hours, Sergeant Barber was in the area of Biddle Avenue and Ford Avenue in a fully marked patrol vehicle when he observed a crotch rocket-style motorcycle at the Wow gas station at 2000 Biddle Avenue with no license plate attached. The motorcycle exited onto westbound Ford Avenue. Sergeant Barwig proceeded to follow the motorcycle. The driver of the motorcycle was wearing a reddish, orange, and black helmet and a black jacket with lettering on the back. The motorcycle was red and black in color. While traveling westbound on Ford Avenue, Sergeant Barwig observed the motorcycle enter the turn lane near 6th Street, past the vehicle. Sergeant Barwig activated his emergency lights to conduct a traffic stop on the motorcycle. The motorcycle continued in the turn lane and passed another vehicle. Sergeant Barwig then activated his audible siren. The driver of the motorcycle disregarded both the lights and sirens and accelerated at a high rate of speed, reaching speeds of 90 miles an hour in a 30-mile-an-hour zone. At this point, the motorcycle disregarded all traffic control devices and signs, including making an illegal turn on the southbound 4th Street. While pursuing the motorcycle on southbound 4th Street, speeds reached over 120 miles an hour. Other Wyandotte officers joined the pursuit, which included Officer Cox, Bro, O'Meara, Saltzman, and Rasmussen. The pursuit continued into the neighborhood near Quarry Road in Ludington, which is a residential area with speed limit of 25 miles an hour. Speeds of the pursuit were well over 60 miles per hour in this zone. Sergeant Barwig ended up losing sight of the motorcycle near 4th Street in Eureka and self-terminated the pursuit. Sergeant Barwig went back to the Wow gas station and spoke with an employee named Habib Samara and was able to produce a copy of a receipt that the suspected driver of the motorcycle had utilized a credit card with the last 4 digits of 4946 and spent $15 on it. Sergeant Barwig also observed a surveillance video that identified the driver as a middle-aged white male, blonde hair with a military-style haircut, and wearing a black jacket with letters of HWK near the neck. Wyandotte officers received information from a caller, Chet Sizemore. He explained that he observed the pursuit heading northbound 4th Street, and then all of a sudden observed the motorcycle come back riding down the sidewalk of Quarry Road near 4th Street, and then he lost vision of the motorcycle. After receiving this information, Officer Rasmussen checked the area of Quarry Road in Ludington and located the suspected motorcycle parked behind 4419 Quarry Road, with the engine still warm to the touch. The remaining officers arrived and made contact with the residents at 4419 Quarry Road and ended up taking the suspected driver, Dennis Rohde, into custody. Officers located the credit card that was utilized at Wow, the receipt, and the keys to the motorcycle in Rohde's pocket, and recovered the jacket he was wearing. Rohde had made statements that he was afraid to stop because he did not have a plate on the motorcycle.
All right. Upon examination of the complaining witness, I do find the offenses charged were committed, there's probable cause to believe that the defendant committed those offenses. And counsel, your appearance, please.
Good morning, Your Honor. Attorney Mark Mandel on Dennis Road, P number 59066. For purposes of arraignment, we'd waive the reading of the formal complaint.
All right. And sir, your name for the record, please.
Say your name. Your Honor, he's hard of hearing. I'm going to help him a little bit. She wants your name. Tell her your name.
Good afternoon, Judge. I am Dennis Rohde, ROHDE.
All right. Good afternoon. Okay. And so the court will waive the formal reading. You do have the right to have an attorney represent you. If you're unable to afford an attorney, you may have one appointed to represent you. And you have, in fact, retained counsel, and you've had an opportunity to speak to Mr. Mandel today. Is that correct?
Correct.
You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes, I do.
Yes. The court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on March 19th. At 9 a.m. And counsel as to bond.
Thank you, Judge. I was just retained last night by Mr. Rohde's wife, Angela. Number one. Number two, based upon information, I believe he has not had any interaction with law enforcement for at least 15 years as it relates to misdemeanors and or felony. There may have been some drunk driving convictions probably 20 years ago, but based upon my understanding, he's been sober, generally speaking, over the last 20 years, a father of 2 children, gainfully employed as a car dealer in Downriver, Dearborn area.
Excuse me. The 2 ladies in the very back. Oh, pause. I didn't tell you to come back in. I'm gonna go ahead.
You invited me back in.
Excuse me. I did not. Back out in the lobby because the 2 of you are doing some other communications right now. You may continue, counsel.
Thank you, Judge. But most importantly, obviously, this court's aware of me being a local attorney. There's no risk of flight in this matter. I believe he does live in Wyandotte with his wife and children. He was referred to me by 2 Wayne County deputies that have spoke highly of him, that this is out of character. But be that as it may, I've heard the allegations. They are what they are. We could hopefully resolve this at a later time in the court system. But with that said, I'm asking that he be released on a PR bond and anything else that the court finds appropriate in this matter.
Okay, Mr. Rohde, where do you work?
You work. She's asking where you work. Where do you work?
I work at Les Stanford Chevrolet Cadillac in Dearborn, Michigan, Judge.
Okay, what do you do there, sir?
I am a pre-owned salesman and Corvette specialist for a used car team.
Okay. And have you ever failed to appear in court for any reason?
Have you ever failed to appear in court?
Have you ever failed
to appear in court?
No, ma'am.
Are you currently on probation or parole?
Are you on probation or parole?
No, Judge.
Are you out on bond in any jurisdiction?
No, Judge.
Sergeant as to bond.
Your Honor, due to the severity of this offense, this fleeing from the police, 9 o'clock at night, in the dark, families out, I am looking for a $25,000, 10%.
Was it raining? Wasn't it raining last night?
I don't believe at that time it was.
Okay. Okay. So the court has some significant concerns for the safety of the public, given the allegations that have occurred in this, or that are alleged in this, that are alleged to have occurred in this case. The court does not find a personal bond is appropriate given the nature of these charges. The court's going to order a $20,000 10% bond. In the event bond is posted, these are the following bond conditions. You are not to operate a motor vehicle at all. Whether you have a valid license or not, sir, you're not operating a motor vehicle. This court has to have some condition whereby it can hopefully ensure the safety of the public. And you are not to be released without a GPS tether from the Wayne County Jail. No house arrest. Any questions?
No, Your Honor.
Thank you. We'll see you back next week. Have a good day.
Thank you, Judge. Thank you.
Thank you.
Well, everybody's asking the question, isn't it all proportional to the last case? That's the $8 million question now, isn't it? I guess it is. But for now, ladies and gentlemen, that's all I really got. I feel like my mic is real hot. Okay. I just kind of looked down and I saw, wow, things seem kind of crazy there for a second. Ladies and gentlemen, it's been one of those nights. It's been one of those nights. What can I say? Started things off with a feel-good with Judge Simpson. Moved very quickly into a very strange case we're gonna have to check back up on come April with Hesselink, with Judge Hesselink. Then we very quickly moved into Judge Bogan and DeSanto, where arguably, and there's some slap on the wrist, but I mean, we don't know the rules of how these people make the decisions that they have to make. And I do know that judges have rules that they have to follow too. I do not envy them in the terrible, difficult decisions that they have to make on a daily basis. Well, thank you all for hanging out with me tonight. Thank you all for checking out these court cases that I found in the dockets today. These are some of the best that I saw that are happening all day today. I will be out looking for more tomorrow. So come on by tomorrow night. Same Wolf time, same Wolf channel. I'll be here. And I'll have more court cases to check out. Hopefully there'll be some of you here to hang out with me and chat. But for now, I'm your Lone Wolf Whistle. I am your humble creator for these here videos. I am your curator for this here channel, archive, court cases. I am the friend of puppies who are asleep on the couch. And I'm your friend too. Thank you all, friends, for hanging out with me tonight. And I will see you next time. For now, I'm out. Oh, and Jess, before I get out of here, just between me and you, thank you so very much. Your contribution so warmly accepted. You know, I just gotta say thank you to everybody out there. I mean, everybody who hangs out and puts up with all the ad nonsense. I can't control any of that. Everybody who hangs out and lurks and just comments, likes, subscribes, and does all that stuff. Guys, you're all amazing. Thank you so much. I can't say thank you. Thank you, thank you. Oh, and Rhonda, Mama, thank y'all too. I don't say people's names enough. Nina, here, Kat, Liz, Becky, Felix, got it. You all. Did I say thank you yet? Oh, I think I did. There's nothing else to see here. Just go. If you haven't watched Ferris Bueller's Day Off, go watch that. I'm done. No more. Bye.